I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Welcome back to the Prosecutor's Legal Briefs. I'm your host, Alice, and I'm joined, as always, by my absolutely immutable co-host, Brett.
Oh, that's right, Alice. Absolutely. Nothing qualified about me.
Nothing qualified about you. You are always the same. You are always there. But I was really proud of my pun. I've been thinking about it all day. All day. I was like, what will I call Brett? I was like, maybe unbenched, because it's like, put me in, coach. We shouldn't do this, but put me in. We're going to get pummeled, but it's okay. But I went with absolutely immutable because obviously we're talking about absolute immunity in the context of Trump. But just erase that part. So before we get to, the really fun argument we're going to talk about today, this was a really long oral argument. It was like, 2.5 hours? More than 2.5 hours long. And you can listen, in case you didn't know this, Supreme Court oral arguments are available via podcast form on, I think, Oyez? Is it called Oyez? Just one Oyez.
Well, you can just go to the supremecourt.gov and they've got it.
Right. But if you're on your phone and you're listening, I listen to it on podcast form if I'm driving around. But it was so long, I hadn't finished it yet. And so I was picking up my kids, but I got there early. So I just walked the parking lot listening to it. But I didn't have headphones on because I didn't think to bring headphones. So I had it blasting while I walked in the parking lot. And, because we're picking up our kids, parents waving and saying hi. And I was and they were oh, you're on a call. I was not exactly, listening to an oral argument. They're your oral argument? I was not mine. I was this is much too complicated. Don't worry about it. And they were did they say Trump? And I was just don't. This is terrible. I really should have brought my headphones. I'm so sorry. All to say is I have finally finished listening to the oral arguments for you guys. And it's a lot. You should listen to it for yourself because I think oral arguments are fascinating, especially on a very meaty issue like presidential immunity, which is obviously the case at issue here.
Yeah, and I think hopefully after you listen to us, you'll be able to listen to it and understand a little bit better. The one problem with oral arguments is the judges, obviously, they already know the issues, but they also have the benefit of the briefs. So they've read the briefs. So sometimes when you listen to oral arguments, they can be very confusing because you're coming in without any real understanding, and it's almost like a bunch of inside jokes. Almost they're talking about things without really explaining any of the premises. So it can be difficult. But I think hopefully after you listen to us, we're going to do a very sort of broad overview. You can listen to the arguments themselves and then maybe get more out of it.
That's a great point, Brett. So in addition to the oral arguments, which is kind of the finale of the show, but there's all the background, which is the briefing behind it. There's not only the briefs of each side of the V, there's also, in this case, I don't know how many amici there are, but a lot of amicus briefs. You don't have to read all of them, but know that there is a huge body of briefs behind these oral arguments. You can access all of them also on supremecourt.gov to read these public filings. At the very least, you can read the opening brief, the responding brief, and the reply brief and kind of forget about all the amicis for now. But as I was heading upstairs tonight, Mr. Alice was y'all are covering a Trump. That's bold. What's your take gonna be? And this is a message for all of you. And I turned to him and I was no take, because you can turn on any channel and get someone's take. Our hope tonight is that these are very meaty constitutional issues that are being discussed that may seem like they only come up once in a blue moon. But as you'll see in oral arguments, this is something that is very core to what we believe the presidency should be or not be. And they are very different positions that people may have. We hope to present to you what was argued there so it's accessible to you. You make up your own minds. Look, the Supreme Court is not going to listen to Alice and Brett. They're going to come out however they're going to come out. But this is not meant to be qualifying which side should be better, which is not better, but rather a lot of really interesting legal issues were raised, and there are arguments on both sides of them. And we hope to present them to you so that you can understand what these arguments are about and to take the politics out of it, because this applies to every person who has held the executive position, not just the person whose name is in the case.
And I think the best way to approach this and to listen to this and to think about this is the same way that all the justices repeatedly said they were looking at this, which this was not really about the case at hand, but this was a decision for the ages. They said things like that a lot. And what impact is this going to have on presidents on down the line, whichever way they come out? And that's the great thing about the Supreme Court is once you get to the Supreme Court, we talk about this sometimes, it stops really being about the particular case, and it starts being about how is the country going to be run long term, how are rights going to be interpreted in all cases, and what powers will presidents have going forward. I'll just give one caveat. I should not have to do this, but if there's one thing I've learned in podcasting, it's that half the time when you say things, people don't listen, and they certainly don't listen if you don't say it. I don't have any involvement in this case whatsoever. I don't know anything about this case, no inside knowledge of this case. I am speaking for myself, not as any kind of representative of the Department of Justice or anybody else. And we're not actually going to talk about the specifics of the case. We're talking about the overall idea of executive privilege. So with that caveat in hand, Alice, should we just go ahead and dive in?
Let's dive in. So this case is Trump versus United States. It was just argued at the United States Supreme Court last week. And let's just lay out what the positions are. So the Trump position is that the former president, and really any president, anyone who holds that position, has immunity for any and all official acts he takes while in office, even if those acts would be illegal otherwise. So think about drone strikes for Obama, Clinton's various military adventures, Bush lying to Congress about weapons of mass destruction. He, the president, does not have immunity for private actions. And so this is for immunity for official acts while in office. And it's an absolute position. No qualifiers, basically. If you're in that position, all official acts, and then we'll talk about official acts later, you're immune from prosecution.
And I think it's very important to sort of lay that out from the beginning, because that was very clearly the argument in the case, but it might not have been so clear to everyone out in the world. The argument is not, by virtue of being elected president, you have absolute immunity from everything you may have ever done before you're president, after you're president, while you're president. That is not the position. The position is that in official acts, acts that are part of being president, you have absolute immunity from those. And you cannot be prosecuted after you leave office for those actions. Unofficial acts, acts that you're doing in your private capacity, those would be different. And obviously there's a question of what constitutes an official act and what constitutes a private act, and that took up a good chunk of the argument. And you had at times various justices asking questions of Trump's attorney about which specific acts would they say are not official acts. And so you had Trump's attorney actually concede a few things, that a few of the things that are alleged in the indictment against President Trump would not be official actions. Those would be in his private capacity. But the point they were trying to make is, to the extent we can all agree that certain actions are in his official capacity, for those he has immunity, he cannot be indicted for them, and he cannot be prosecuted for them. And the way this would work, if you assume that the president does have some sort of absolute immunity after he leaves office for these actions, is you would have to have some sort of hearing, probably, before the lower court, and you would argue about these things. And you would have sort of the law would be the president is immune for these official actions. So now we're going to figure out which ones are official, which ones we can all agree on, which ones we can't, and the judge would decide. And then you probably would have some sort of appellate process. You have this in qualified immunity, for instance. So in qualified immunity cases, take a police officer. Police officer does something, a person sues him and claims, this violated my civil rights. I should be able to bring a lawsuit against this officer. The officer can claim something called qualified immunity. The judge makes a decision about whether or not this is covered by qualified immunity. If the judge says no qualified immunity for you, you actually have a right for immediate appeal. So that officer can appeal directly at that point, go through the appellate process, and either the appellate courts will agree with the lower court or they won't. If they agree, case goes away. If they don't, then the case would continue. You would have a similar thing here where you would make those decisions. And the position that Trump is trying to make is, hey, there should at least be some absolute immunity for some crimes. It's important to note the lower court, which is the D.C. Circuit Court, basically said there's no absolute immunity. And we're going to talk a little bit more about that in a second. That was a position that did not get a lot of traction in the Supreme Court, and you'll see why. So one question that was immediately asked of the lawyer for President Trump was, where does this come from? I think Justice Thomas asked the first question.
And by the way, Justice Thomas for a long time didn't ask a single question, but since he started asking questions, he's usually the first one out of the gate. And this is a good question to ask because whatever side you come out on it, we've talked about this, that these rights don't come out of nowhere. So for him to ask this kind of foundational question is really important for both sides to answer, because if there is a basis or a genesis of this particular right, the other side then needs to address that. So I thought this was a very good first question because it lays the foundation of what we're about to talk about.
And so his question was, where do you get this? Where does it come from? And one thing that, well, they attempted to do this, and I'll tell you why, but there's nothing explicit in the Constitution that says the president has absolute immunity for actions he takes while in office, which may be illegal. There's nothing that says that. So that obviously would be helpful if it said that, or if it said the opposite, but it doesn't say that. So what you're going to have to do is you have to figure out somewhere else. Where is this coming from? And the first place that the Trump position sort of attempts to anchor this position in is the vesting clause of the Constitution. So the vesting clause of the Constitution is the first clause, first section of Article 2. Article 2 is what deals with the president's powers. And it says, the executive power shall be vested in a president of the United States of America. That's what it says. And you may think, that doesn't seem like it says a lot. But that clause carries with it so much baggage. Because when the founders were drafting the Constitution, and there were arguments about the convention, the Constitutional Convention, and there were citations. I mean, this was like the most history-laden argument you're ever going to hear. They're talking about the records of the Constitutional Convention, what was said in them. The executive power being vested in a president. What is the executive power? Well, it includes essentially all the trappings of the king. So you look back to the British monarchy at the time of the founding, and from that, you sort of derive what powers are going to be inherent in the president. The Trump people, and we're going to read from Marbury versus Madison some today, referred to Marbury versus Madison a lot. Marbury versus Madison is an 1803 case. It is foundational. If you are in law school or ever studied any kind of constitutional law, you've probably read it. And it talks about this, how the king and the king's prerogatives and the king's authority, and where the king, for instance, could be required to do certain things and where he was absolutely immune, as it were, from being forced to do anything. So the position of the Trump people was like, look, when Congress, the Continental Congress, the Constitutional Convention, when they imbued in the president the executive authority, in doing that, that included some amount of immunity, some amount of executive immunity that is going to apply to the president for the actions he takes in his official capacity as president. What's interesting about this is there wasn't a whole lot of pushback on this. You know, there wasn't a whole lot of, oh, is that really what that means? Or how can you get so much out of that? It was sort of accepted that, okay, if this exists, you're probably right. That's probably where it comes from. Now, there's plenty of pushback on what that means, but it seemed like this first part, at least, was relatively uncontroversial that is where this is going to spring from, to the extent it springs from the Constitution itself.
So the general structure of the Constitution and the founders' desire was to avoid factionalism. Right, we're looking back to the founding because the founders would not have wanted, and I don't think this is something we want today either, a system where a president's successor government would prosecute the last president every time parties change, so that basically you use political warfare to attack your opponents just because they're of a different party. But then Justice Kagan comes in with a question. What if the president ordered a coup? Is that going to be subject, in their official capacity, is that going to be subject to absolute immunity?
And that was a tough question for the attorney for President Trump. And if you listen to him, he's a very good lawyer, by the way. And he does the thing that John Sauer.
If you're looking for attorneys.
He does the thing that you do when you're in an oral argument and you get asked a really tough question, which is basically say, well, I'd have to have all the facts to be able to answer that question. And by the way,
this had to have come up in a moot. Like this is the obvious question, right? You're going to go for something extreme and something that seems utterly unlawful. So this is the right question to ask, because as you'll see with the questions, you're trying to figure out what side you're on of the question, but then there's scope as well. We're always talking about the extremes because these laws, the law, supreme in the land, is going to apply to all situations in the future that we may not be able to foresee. And that's why the justices ask these extreme hypotheticals to try and whittle away at what is actually acceptable and recognizing that there may be illogical ends to these decisions.
And, at that point, Justice Kagan, who's a very good justice, said something along the lines of, that sounds like the kind of answer you give when the answer is he would still be immune, but you don't want to say that because it sounds really bad. And
she's right. And she called him on it, though.
And it was great. And to his credit, he said, yes, it does sound really bad. And this was something that he came back to several times whenever pressed on these hypotheticals. So I think Justice Alito mentioned SEAL Team 6. The president orders SEAL Team 6 to assassinate his political opponent. And then you have Justice Kagan talking about he orders a coup. And what he essentially said was, look, you have these dangers if the president has absolute immunity, and you're pointing out these dangers. These are extreme, they are unlikely, and they would require the assistance of a whole bunch of other people to do something that violates their constitutional oaths and that is illegal, and for which no one doubts they could be prosecuted. The other thing everyone agrees on here is, to the extent this absolute immunity exists, it only applies to the president because he is the one vested with the executive authority. He has the immunity. All of his subordinates, if they're committing crimes, they do not have immunity.
That's a really, really good point to make here. So think about all the staffers that work for them, all the people who would take the orders, all the people who work for the people who take the orders. I mean, this is important to think about because we think about all the terrible things one person could do, right? The executive. But he'd have to convince a lot of people who are not absolutely immune, as he is arguing he should be.
And so you have that outcome versus the other possibility, which is if he doesn't have absolute immunity. In that case, you're going to have presidents who are being prosecuted. Basically, every president's going to be prosecuted. It's kind of like the sort of impeachment thing. Everybody gets impeached now, right? Like, it seems like people are being impeached all the time these days. Used to, you didn't have impeachment very often. Then you had President Clinton, who was impeached. And then everybody was like, you should impeach people, but nobody was. And then President Trump was impeached twice. And now the Secretary of, I don't even remember, just got impeached.
Yeah.
Right. And so the argument is, look, much more likely is you're just going to have people prosecuting each other back and forth. And you're going to set up a situation where every president feels like he has to pardon himself at the end of his presidency. And then you got to decide whether or not you can even do that, whether that's even something you can do. And I thought one of the weaker arguments from the government on the flip side was they brought this back up to him and said, look, isn't this going to set up where every president's going to have to pardon themselves or want to pardon themselves? And he was like, oh, no, I'm sure that wouldn't happen. It's like, I mean, I just got to tell you, I think if President Trump were to win this next election and I'm President Biden, I'd go ahead and pardon myself. Like, I wouldn't think twice about that. So it was an interesting sort of you're presenting the worst case if we win. How likely is that versus the worst case if we lose? These policy style arguments you actually don't often see in the lower courts because everything is much more sort of, what does the law say and all that stuff. You have the policy arguments, but not so much. But once you get to the Supreme Court, then these policy arguments become much more sort of at the forefront. And you have people really talking about this and dealing with this. And it's not going to be the only sort of policy consequence argument you're going to see. Now, one interesting thing that also came up in this point was the impeachment clause. So obviously, the president can be impeached, and both sort of sides of this use the impeachment clause to sort of support their position. Because, one interesting thing, Justice Jackson brought up, she said, look, if we do this, and the president doesn't have to worry about being prosecuted, isn't he going to be the seat of criminality in the United States? Because he'll come into office and he'll just know, I'm now immune. I can do whatever I want. And there were two sort of counter arguments to this. The first one was, well, no, because private actions will still be prosecutable. But the second one went kind of along with the impeachment clause. And that's that essentially the president, whatever you think about prosecuting former presidents, while the president is president, he absolutely has immunity. There's no question about that. So the president, while he's president, can do anything he wants, and he can't be prosecuted while he's president. The only way he can be prosecuted is if he is impeached and removed from office, at which point he could be prosecuted. So some of the worst case scenarios, the assassinating your opponent, the coup thing, even under current law, the president could not be prosecuted for those things as long as he can stay in office. So maybe the coup is the ultimate one. If he pulls off the coup and he stays in office, even under current law, he couldn't be prosecuted.
And the idea behind this, right, is that our president is limited to a term of 4 years and then only 2 terms. But the idea is that it takes a lot to govern a country. And if you could attack us, as a country by just prosecuting every one of our sitting presidents and we never have a leader. So that's the idea behind not prosecuting a sitting president. It may have to wait until after they're not sitting anymore. But just know that part is actually, no one disputes that whatsoever. And so, we came into this argument with...
And that goes back to the whole, the president is the king type thing. We like to tell ourselves that no one's above the law, but in many ways the president is above the law because he is the law. So he is the executor of the law. And he is able to do things while he's president that he's not going to be punished for. And this stuff comes up a lot. And you see this a lot. We mentioned earlier that sort of DOJ position about murder. So, and this comes up a lot once the government gets up. But drone strikes, there's a DOJ opinion. It was actually written by my former property professor, David Barron, who, and if you've never read it, in many ways, if you're worried about the implications of this case, reading that memo will chill you to your core because it's all about how the president essentially can do this and he's not amenable to the criminal statutes about murder. It comes from ordering drone strikes on American citizens. So you order a drone strike on an American citizen who's not in the United States and you can't just go arrest him. Can the president be prosecuted for that? And the answer was no. And there's all sorts of reasons why. And the complexities of this are where this argument started to get more complicated than you might have thought. I think most people, when they walked into the argument, thought, and even I said this in one of our chats, that, well, this seems pretty obvious. This is going to go really poorly for Trump because they're just going to say this is silly. What are you even talking about? But the more you talked about it and the more they sort of dug into it, the more you realized this is actually pretty complicated. Justice Jackson at one point said, what if we just said, look, the president doesn't have any immunity, no immunity whatsoever. We're going to treat him like everybody else. He's not above the law. She sort of throws that out there, and nobody picked it up. None of the other justices, neither side.
Not a single one.
Nobody.
Doesn't matter which side you are.
Yeah, they were just like, not going to go there, right? So that's where it got weird.
And here, I mean, here's the thing, right? I mean, and that's the other extreme. We talked about whittling down of the scope, understanding even what the scope is. We have absolute immunity for all things that are official and then no immunity whatsoever. I mean, we are a massive country, right? Both geographically and in terms of the complexities and the dependence of many other economies on our economy. And we depend on a certain level of leadership. And we obviously came from a monarchy where we didn't want absolute, kings and families of kings for generations to rule us with absolutely no recourse. But we needed something along the same levels that could provide the same level of leadership for a world power. And so this is what the founders came up with. So those of you who are thinking like, why? And that's why I think a lot of you are probably thinking what Justice Jackson ultimately threw out. Why have absolute immunity at all? And just so you know, I mean, our country depends on leadership. And there's a reason why none of the other 8 justices backed her up whatsoever. They didn't even entertain the idea because it's a good thinking question, but not really for reality. And they are dealing in reality here, not just in esoteric theories in academia.
And what was really interesting about it is listening to it from sort of someone who spent a lot of time studying the founding period in college and listening to the justices repeat things that just aren't true. One of them was that the founders, their main concern is they just fought a revolution against an absolute monarch and they wanted to prevent that. That is not entirely true. In fact, the group of people that the founders really didn't like was the Parliament. They really had a problem with Parliament. And there's a period right before the revolution where they send something called the Olive Branch Petition to the king. And they're like, hey, man, king, these people are taxing us like crazy. We need you to help us out here. Like, do something for us. And the king ignored it. And this was like a shattering moment for the people in the country because they still loved the king. George Washington toasted the king until the Declaration of Independence, basically, because it was Parliament that was the problem. They were the ones doing all the things they were mad about. And so after the revolution, when they all get together to do this Constitutional Convention, Thomas Jefferson's off in France, like doing who knows what. It has nothing to do with the Constitution. So you got Madison and you got Hamilton and all these guys helping draft the Constitution. And they spent a lot of time on Article 1. And Article 1 is very detailed. It really lays out powers of Congress, the Great Compromise, how we're going to have, large states will have power in the House and small states will have power in the Senate and all these things to make sure the legislature isn't trampling on our power. And then you get to Article 2 and they're like, and they just sort of write this very brief section about the president and the power he's going to have. And Hamilton, in fact, was basically a monarchist. He was kind of like, I think the president should have even more power. And Madison was like, oh, I don't know, maybe not that much power. Then Jefferson.
Hamilton wanted George Washington to be president forever. He wanted him to be the king.
Yeah, Hamilton was basically a monarchist. Jefferson gets back from France and is like, what in the world did you people do? Like, you basically have recreated the monarchy. And he freaks out and he ends up establishing the Democratic Republican Party, which challenged the Federalist Party, whatever they called themselves, and ended up taking over government. And Madison was just like, oh, yeah, those crazy people couldn't do anything. So I'm with you now, right? But so it's this wacky situation. And that's one of the reasons that they really didn't flesh out the limitations here. And when you read Marbury versus Madison, which we're going to get to now, this came up a lot in the argument about Marbury versus Madison. And I had forgotten this part of Marbury versus Madison. I don't think you read this part in law school. You skip to the part about, it's whatever I can't remember. I'm a bad lawyer. I can't quote the part anymore. Something emphatically the duty of the judiciary to say what the law is, whatever. And there's that part, and constitutions are written so that blah, blah, blah. Right. So that's what you read in law school. But there's this other part that's all about the president. So I'm going to read this to you because this came up a lot. So in Marbury versus Madison, for those of you who don't know, you had this dude, Marbury, who had gotten a commission under John Adams, who was one of those crazy monarchists that Jefferson didn't like and had defeated in an election. And he'd gotten this commission to be like a judge in D.C. or something. It was like some 10-year position he was going to get. And it got signed and everything. It was just never delivered to him because before it could get delivered to him, Jefferson and Madison show up. And Madison gets the commission and never delivers it. So Marbury files a writ of mandamus, basically command Madison to deliver this commission to me so that I can begin my position. Because the rule was, until the commission is delivered to you, even if it's signed and everything else, you're not actually in the position. You have to get the commission. So he sues, and it goes up in Marbury versus Madison. So the question was, what happened here? What can you do here? And the Supreme Court says, look, it's clear that Thomas Jefferson and Madison are violating the law here. This is illegal what they're doing. This guy is absolutely entitled to this. It should have been delivered to him. And then they get into this. So could they do anything about it? So I'm just going to quote from the case. By the Constitution of the United States, the president is invested with certain important political powers, in the exercise of which he is to use his own discretion and is accountable only to his country in his political character and to his own conscience. To aid him in the performance of these duties, he is authorized to appoint certain officers who act by his authority in conformity with his orders. In such cases, their acts are his acts, and whatever opinion may be entertained of the manner in which executive discretion may be used, still there exists and can exist no power to control that discretion. The subjects are political. Then the court goes on to ask whether it has jurisdiction over any of these activities. It is scarcely necessary for the court to disclaim all pretenses to such a jurisdiction. An extravagance so absurd and excessive could not have been entertained for a moment. The province of the court is solely to decide on the rights of individuals, not to inquire how the executive or executive officers perform duties in which they have a discretion. Questions in their nature political, or which are by the Constitution and laws submitted to the executive, can never be made in this court. And that's the heart of what's going on here. Trump is saying these actions, if they are official actions, are beyond review. I can't be charged for them. You can't say I can't do it. I am completely immune. The only thing is I have my own conscience and the political, results, right? Maybe I don't get reelected or whatever. Sort of that's the position he's trying to say. And they're using the combination of the vesting clause, the impeachment clause, and Marbury versus Madison, as well as quotations from Ben Franklin and George Washington. Like I said, this is very history based to support this position.
Okay. We're half an hour in. So we've laid out Trump's position, the questioning that came with it. Let's lay out the government's position. So initially, when the government started arguing, it said that there was no immunity for former presidents, in keeping with the D.C. Circuit decision below. But honestly, with just a little bit of pressing from the justices, this position quickly fell away and they needed to step away from it. So Justice Gorsuch attempts to nail down whether the government truly believed there was no immunity for former presidents. Now, the response was that the president could have an as-applied Article 2 constitutional challenge to any indictment for actions that fell within the core executive power. And Gorsuch suggested that we could use a shorthand for such a challenge: immunity. I chuckled out loud.
I think everybody laughed, except for the lawyer for the government.
Because he backed him into it. He's like, oh, you're using different words. I mean, this is what lawyers do, right? He gave the definition, essentially, of immunity, and Justice Gorsuch got what he wanted, which was that, no, you don't really hold the position that there's absolutely no immunity for former presidents. So once Justice Gorsuch got them to back away from that position, which I think they had to back away from that point forward, the government really didn't defend the no immunity position, and that kind of is off the table now. So no longer are we saying this is an argument between no immunity versus absolute immunity. It's somewhere on the spectrum now. And this is what we mean about the justices asking these questions to figure out the scopes, because you can take those positions, but when those positions are unsupportable, then the arguments begin to change and shift to something else. So, yeah, this is in real time. You got to know what you got to concede.
And this is, again, one of those things that obviously during a moot, they came up with this answer, an as-applied Article 2 constitutional challenge. So for those of you who don't know what that means, and there's no reason you should, so Article 2, as we just established, is the article that gives the president all his power. An as-applied challenge means your law might be constitutional. You may be able to do that to somebody else, but you can't do it to me in this circumstance. So the president, what would he be saying? That law doesn't apply to me because when I did the thing you accuse me of, I was president. So therefore, under Article 2 of the Constitution, I have an as-applied challenge. You have to dismiss your indictment. That is exactly what absolute immunity is. There's really no distinction. And the government, when pressed by Gorsuch, and when Gorsuch makes that joke of, well, how about we just call that absolute immunity? I mean, there's no pushback because, okay, yeah, you got us. That is what we're suggesting. And at that point, the question becomes, it goes back to the Trump argument, essentially. Well, what does that mean? So what's really fascinating about this argument is it starts off from this D.C. Circuit opinion that says there's no absolute immunity, that essentially says, and the government even called it a tautology, that the president's not immune. We know he's not immune from prosecution because he's being prosecuted. If you want to know what a circular argument is, what begging the question is, that is it. You're not immune because you're being prosecuted. You can be prosecuted because you're being prosecuted. And the government admits, yeah, that's a tautology. It doesn't really have anything to it. The Chief Justice actually brought this up, Chief Justice Roberts. And Roberts is always the guy, the like reasonable man in the middle, right? When you look at this court, that's where he always wants to be. So the fact he's pointing that out about the D.C. Circuit opinion is really bad for the D.C. Circuit opinion. So you started there with just, well, maybe there is an argument there's no absolute immunity. Very quickly that fell away. Now you're in a position where it is clear there are things the president can do while he's president for which he cannot be tried later. Now, some of these things that everybody agrees on and the government was willing to concede, and this is great. Kagan, once again, you know, I've told this story before. Kagan was my dean when I was in law school, and, you know, Kagan and I would occasionally get into disagreements of various things, and very rarely did I ever come out on top of those disagreements. And by very rarely, I mean never. She's very smart. And she's the one, in a lot of ways, in these arguments, when everybody else is being sort of very high-minded and philosophical, she kind of cuts through it and gets to the point. And so she does that here. She's like, what are they? Just tell me. What are the number of actions that you believe a president could do and not be prosecuted for? And some of the things they mention are appointing people, the pardon power, foreign sort of interactions, the war power, which is an interesting one because once you're immune into the war power, you can do a lot of things. And this brings up actually a lot of those examples, just to give you some examples, because it's hard to think about this case and not think about Trump. Just a few examples. So President Lincoln, during the Civil War, he suspends habeas corpus. Probably can't actually do that. That's something Congress is supposed to do, not the president. He does it. And he's arresting people in Union territory and Union states, holding them in shackles until the end of the war with no trial, right? Can he be prosecuted? I mean, were he to have survived his 2 terms, could he have been prosecuted later on for that? Probably not, because it was part of the war power. You know, President Clinton gets brought up a lot. I mean, you guys who were alive in the 90s remember, whether it's true or not, there was always this joke that whenever anything bad happened to President Clinton here, whenever he got a scandal, he'd bomb something. So he bombed like a place. It was supposed to be a chemical factory, and it turned out to be some sort of, you know, like drug factory, like a Tylenol factory or something. There's a famous story about how after the Monica Lewinsky thing, Hillary Clinton wouldn't speak to him and didn't speak to him for a real long time, but finally called him because she thought it was really important that the United States intervene in the Balkan crisis. And so in response to that phone call, President Clinton launches airstrikes. I mean, why can you, if you're the next president, if you're President Bush and you don't like President Clinton, can your Department of Justice prosecute him under the theory that he was using the military to accomplish his own ends? The thing about President Bush, you know, President Bush orders someone to go, and this is all just, you don't have to believe any of this is true. It's just, could they be indicted and prosecuted for it? If President Bush orders someone to go lie to Congress and say, there's WMD in Iraq and we have to invade, and the whole reason he wants to do it is either because he's still mad at Saddam Hussein for trying to assassinate his father, or maybe he thinks it'll be good politics. going to be prosecuted later on for that. And these are the sort of things that are bubbling up, and the government is sort of forced to say, well, there's a broad range of things, right? Well, they say it's not broad. They say these are the core powers, but when they start listing the core powers, it feels broader and broader. The problem is when they start doing this, it makes their what had been a very clean, clear-cut argument a lot more complicated, and probably is going to have all sorts of consequences for them down the road in their criminal case. As I said earlier, the DOJ memo from the Obama administration, which is very broad, Justice Barrett brings it up and really presses the government on it. And I think if you listen to this argument, listen to this part and then go read the memo, because the government is trying really hard to explain how that memo isn't saying the president has absolute immunity for the things he does. They, much like they do with the as applied Article 2 challenge, they have like another term for it. Well, it's not actually absolute immunity. It's just this law doesn't apply to him if he's acting as president. Which, once again, what is that? Is that immunity or not? And that's sort of a thing that the government's having to fight with the whole time, because they want this to be very clear. Now, one thing they never do, which I would have been very tempted to do if I had been them, would have taken the sort of I know it when I see it argument. So there's a famous argument about obscenity and pornography where the Supreme Court basically says, normally we sort of lay out bright line rules for you guys. Can't do it here. No idea. We know it when we see it. Was the position. And I almost feel like the government might have been better off if they just come and said, look, this is really complicated, and we don't know how to tell you where to draw these lines. All we know for certain is the things we're talking about in this case, there's no absolute immunity for. That's all we know for certain. These things. Just limit it to these facts and you'll be fine. You don't have to create a rule for the ages, which is what they kept talking about. But the government just could not bring itself to do that. And it never did it. It never just said, just look at these facts. Don't worry about all this other stuff. And I almost feel like if they had done that, and look, that may be what the opinion ends up saying, but the government never took that fallback position. Never. And I think, and that was a conscious decision. It had to be a conscious decision, because you're always thinking about what are my fallback positions going to be? How far am I willing to go before I'm just not willing to go any further? And they apparently had decided they were not going to go that far.
Yeah, that's a really good point. I mean, these things are mooted, and the decisions are made, far beyond the person who's actually arguing it, and they know kind of the parameters in which they are allowed to concede. And so kind of going back to this Obama era DOJ memo explaining how the murder statute does not apply to the president, which really does sound like immunity to me. It shows, and this exposed kind of the weakness of the government's initial position that there was no immunity for former presidents, because the government's now suggested fallback position, which is not what Brett just laid out, but this kind of like, there could be some as applied Article 2 challenges, Gorsuch calling it absolute immunity, is actually, in fact, based on that memo and kind of other examples from past administrations, that the DOJ had signed off on these actions that gave the president protection. So the government suggested that if the attorney general advised the president he could legally take an action, that advice would forever immunize him from prosecution, which of course sounds like absolute immunity. And look, this is tough, right? Because there are all these memos, all these opinions from past administrations and different fact patterns. And I think that's why it's really attractive what you just said. The, obscenity standard of I'll know it when I see it is because history is long, and presidents have had to make, we now have the hindsight of 2020 on a lot of those actions, and they now may seem absurd, but in the heat of war, in the heat of post 9/11 terrorist attack, what have you, those decisions may have seemed reasonable. And that's kind of the argument for absolute immunity, right? You don't want a president who's gun shy about making important decisions that could very well be, the fate of the country or the fate of kind of peace in the world, because they're thinking about getting prosecuted for some decision later. That's the argument. That's one of the arguments that comes up over and over as to why the president should have immunity, to not have a chilling effect on real leadership.
And once again, this had to be something that came up in a mood, because it's a good argument. You want the president to be able to act freely without fear of prosecution when he is, truly attempting to do the right thing, and he might mess up. deciding whether or not to drone strike an American who's also a terrorist, that's a tough call. And you want the president to be able to make that call based on national security and everything else, even though that may sound like murder. If I walk into a restaurant and I see a guy who I know is the head of the most violent, terrible gang in my city, and I pull out a gun and shoot him, I can't say, and nobody would think I should be able to say, well, look, we're all so much better off. It's so much better that he's dead. Like, I have taken out the leader of this horrible gang. We've been trying to arrest him for forever. Nobody's ever to make anything stick on him. So I just had to take action in my position of as a prosecutor, right? Like, that's just absurd on its face. But those are the kind of things the president has to decide. You got a guy who you can't get him. It's not like we can get our hands on him. Or even if we could, it's so dangerous to do it. You know, he's not Osama bin Laden. We're not going to send in a SEAL team to get this guy and risk that. But he's incredibly dangerous. He's also an American. What are you going to do? And there might be plenty of people who say that awesome power should never be in anyone's hands, including the president. The president should not be able to make that decision. And if a president decides to do that, that is murder, and he should be held accountable. You might say that. Maybe you believe that. I don't believe that. I have no problem with what President Obama did. And I certainly don't think he should have to answer for it in court, even if I did disagree with it. So you've got that issue hanging over you. So how do you answer that if you're the government? When that's sort of the Trump position coming in, is if you strip the president of all absolute immunity and you leave him open to prosecution the moment he steps out of office, is he going to be able to make those calls? So essentially, and I don't know. I mean, I thought this was kind of a wild position that the government took. It was almost like a rule of two. So we're not going to say the president by himself has immunity, but if he can get the AG to sign off, it's kind of like, you know, how on every nuclear submarine, if you've ever seen Crimson Tide, I just assume this is true. There are two keys and you can't launch the nuke without two keys. And so if one person says no, you can't launch the nuke. Well, it was almost like that. Like, the president can do whatever he wants as long as his AG says it's okay. Now, JFK was in a great position because his AG was his brother. So he probably could have done whatever he wanted. I assume his little brother, who he made the attorney general, would do whatever he wanted. And obviously, what are you going to do if you're the president? Are you still going to look for the best and the brightest? You know, just assume we live in a Pollyanna world where the AG, we look for the best and the brightest. And we want someone with sort of independent views to give us independent legal advice because we want to really know whether it's right or wrong. Well, in this regime, a lot of presidents would just pick whoever they know is going to do whatever they say. They're going to pick a rubber stamp. And according to the position of the government, if that rubber stamp comes up and says, yes, Mr. President, of course you can have a coup. Great. Of course, Mr. President, you can assassinate your rival. Great. I mean, that's not a world you want to live in. So obviously, even if you made that rule, it's not going to be real, right? You're going to have some sort of standard for when the president can rely on the AG's opinion. And then what does that even mean? It's just so messy. And this was something that the government used as their fallback position to sort of try and take away the sting of the Trump position. I don't think it really worked. I think most people, the questions for the government from both sides of the political spectrum on the Supreme Court were like, how can that possibly work? How can it possibly be that if the AG says it's okay, it's okay? So I don't think that fallback position really has much chance of being the position. And just to say this, the whole reason for that is there's just sort of a theory in the law that if you get sort of sign off, you know, if you give the sort of prosecuting authority all the details of something and they say, no, of course you can do that. That sounds perfectly fine. And then you do it, they can't turn around and prosecute you for it. There's a due process, fairness thing there, right? So the theory here is, since the Attorney General is the head of the Department of Justice, if he says, yes, Mr. President, that's fine, and you do it, the Department of Justice could not then turn around and prosecute them under the same theory. And I get sort of the logical comparison there between those two, but as a practical matter, given the relationship between the president and the AG, it doesn't really work out.
Yeah, again, I understand where they came to it academically, but I think I do not think immediately the justices kind of dismissed it out of hand as a ridiculous position because of the world we don't want to live in and also administrability. So I think I don't know. I'm a little bit confused on some of the positions that the government took because ultimately I think it backed itself into a way that everyone agrees there's going to be some immunity. And I think if the government took some positions earlier on to make it more about scope, they may have gotten more gains at the beginning of it. So ultimately, I mean, look, everyone agrees, except for Justice Jackson's one question, what about no immunity? The fact that no one jumped on it lets you know that there's going to be some absolute immunity. And this is going to be about scope. And what that means is some variation of the position Trump brought in is going to prevail. Now, to what degree is going to be, the devil's going to be in the details. It's going to be really interesting what the opinion looks like. But don't be surprised when the opinion says they're not going to take the government's initial position. I don't think they're going to take their fallback position.
And what's really going to be interesting is a question that Trump's attorney kept getting because it was a really hard one for him. There were hard questions for both sides. Both sides, their arguments, it's funny because both sides took, at least initially, the most extreme position. The Trump position was basically everything the president does while he's president, he's immune for. That was the beginning position. The government's position in the beginning was basically he doesn't really have any immunity. Very quickly, both of those fell away. Very quickly, the position mutated on the Trump side that, well, it's not anything he does, it's purely official acts. And one of the hypotheticals that came up a lot was bribery. So the courts have said before that bribery is a private action. And, if you accept a bribe, you're doing that privately. Obviously, you're getting the bribe because of your position and because you have the power to do something. But bribery itself is a private action. So the question that came up was, okay, everybody agrees. The government agreed when they mentioned it, the pardon power. So pardon power is one of those core things the president can do, and he can't be prosecuted for it. But what if he gives a pardon in exchange for a bribe? Or what if he appoints someone, another one, can't be prosecuted for? What if he appoints someone in exchange for a bribe? How does that work? And the Trump position was never quite clear on that. It was, well, you have to excise the official part out of the indictment and just leave the other part. But then I think it was Chief Justice Roberts was like, well, then you have a one-legged stool, which they love that. I don't know why courts love this whole stool thing, that like if you take away the legs of the stool will fall over, I guess. So
it's always like a three-legged stool.
Yeah, usually
instead of a four-legged
stool. It starts off as a three-legged stool, and then when you take one of the legs away, and this one got all the way down to one leg. So this was a one-legged stool. But his point was, how do you prosecute somebody for bribery if you can't mention the thing they did to get the bribe? Now, how does that work? And it was never clear. There was never that question for either side, because both sides are saying that the pardon power and the appointment power is this core thing for which he has immunity. It was never clear how they're supposed to draw that line and how exactly they're supposed to figure this out. And, I don't really know what the court's going to say. That was this. The reason this one's fascinating, one of the reasons we wanted to do it, is because a lot of times when the argument's over, I have a pretty good idea what's going to happen. And not only what's going to happen, but how it's going to happen, right? Like the lines they're going to draw and sort of the rule they're going to lay down and all this other stuff. You never know for sure. But this one, when it was over, I was like, I have no idea how you write this opinion if you're the court. Like, I really don't know how you do it, because in some ways, Justice Jackson's would be the easiest to write. Or if you just took some extreme view of the president as basically just he's king, and what he does as president is what he does as president, and unless he gets impeached. This was the other thing that I thought was interesting, because obviously you can impeach a president and prosecute him. The problem here was the stuff that Trump's being accused of all happened at the very end of his tenure. So he couldn't be impeached. And so there was this sort of question hanging out there that nobody ever answered, which is, can you impeach someone after they leave office? Because if you could, that would actually take some of the sting out of this. Because if you had a president who attempted a coup or assassinated his political rival and then gets booted out of office anyway, because remember, they have to be out of office, you could impeach them and then prosecute them for it. So, like, that would be one way out of the box, but that was never suggested by anybody. And it's just an open question whether or not you could impeach somebody after they leave office. There is an OLC opinion. So the Office of Legal Counsel is an office in the Department of Justice who often puts out legal opinions. And we've just decided that no matter who's president, no matter what political party, when they say it, we're just going to assume that is like really, really, really persuasive. So if OLC says it, it must be true. So I think there's an OLC opinion that says you can't impeach someone after they leave office. But just because OLC says it doesn't mean it has to be true, right? There's an OLC opinion about whether or not you can pardon yourself or not. So these are just questions that I don't know what the answer is going to be.
And I think that's a really great point, because it's clear it's not going to be the extremes. It's somewhere in the scope in between that is unclear. And that's why I think you've seen a lot of legal commentary saying, well, what's going to happen is they're just going to remand and let the district court figure out what's an official act. Here's the thing. There is a legal question before the court now, and they need to kind of draw some sort of understanding of what the scope is at all. We know that there's going to be, or I think we know that there's going to be absolute immunity. The scope of that is confusing. I don't think they can leave it completely undefined and just be like, yeah, I don't know, like, good luck, because it's going to come right back up in this particular case. In Trump versus United States, it's going to come right back up. So they're going to have to deal with it eventually. But how they write that and how they get enough votes in order to have a majority opinion is going to be kind of a head scratcher. Some of you asked, are they going to speed this up or, wait to the end of the term? Here's the thing with the Supreme Court term. It's already the end of April. The Supreme Court has all its opinions out by the end of June already. So we're already at the end of the term. This is one of the last oral arguments. They're already at the rush. There are a lot of opinions that need to come out. And this is not pre-written. I would be surprised if it were. This is going to be a lot of back and forth among all the justices in terms of what the opinion will look like. So, I mean, we are going to get a lot of opinions in the next month or so. I don't know that this one's not going to come out next week.
They could dig it.
They could dig it. It's been a while since they've digged a case with. I don't think after a 2.5-hour argument they're going to dig this case.
So when you dig a case,
oh my gosh,
that
actually made me laugh. Thanks for that.
It means you dismiss it as improvidently granted. So basically, you say, you know what? We have no idea. Never mind. It's
literally a throw up your hand sort of thing. They're not going to do it in this case. So one of my friends was arguing a case at the Supreme Court, and it was a boring, this was not like a hot, meaty issue at all. It was kind of a boring issue, like a civil procedure. And even after the case was granted, all the legal commentators, because everyone pays attention to the cases, right? Like, there's only 70 or so cases granted a year. It's a big deal to get granted. And every legal commentator was trying to figure out why this case was granted, because it was not clear. There wasn't some piping hot issue. The facts were so steamy. There was some grave injustice. There was some, area of the law that the court just really needed to explain. And there wasn't even that much of a fight among the two sides. So my friend gets up, starts talking, and Justice Gorsuch says, I just got to ask, why did we grant this case? And everyone in the entire courtroom starts laughing, because everyone had been asking this question for a year since it got granted. And the lawyer was like, well, Your Honor, the court is very smart. It knows exactly what it wants to do. And Justice Gorsuch was like, no, we don't always know what we're going to do. And I think we kind of messed up here. I'm not sure why we granted for oral argument. And everyone laughs again. And the lawyer's like, well, personally for me, I'm really glad you did, because he got an oral argument out of it. But even in that case, they didn't dig the case, is my point, right? Literally, the first question out of a justice's mouth was, this was improvidently granted. Don't know why we're doing this. This is a waste of everybody's time. There was still an opinion at the end of that. They did not dig it. So it is a tool the court can use. It is rarely used.
So just to give you an idea of what could happen, I think there are, well, I don't know how many this is going to end up being. But number one, okay, they could just affirm the lower court and say, you know what? Sorry we called your opinion a tautology. after hearing the arguments, we understand why you did what you did. Go with that, right? They're probably not going to do that. So what they're probably going to do, and then on the other extreme, they could say something along the lines of the president has absolute immunity for basically anything he does, even bribery. You've got to deal with that through impeachment. Sorry, we're just going to say that you're immune for everything. Or the more likely thing is some mushy middle where basically they say, and the good thing about being on the Supreme Court is you can always say, we're going to answer these questions later. So they could say something like, the president does have absolute immunity. We're not called upon to say what specifically he has absolute immunity for, and we will address those in future cases. But we leave it to the wise lower courts to more thoroughly adjudicate what it means to be in official action, something along those lines. Even if they don't do that, even if they lay it out and they lay out a test and say it has to be these things, has to be an action he takes for these reasons, or whatever they say, if it's somewhere in the middle, I think the practical thing you're going to see is any case brought by the federal government, you'll have to go through some sort of briefing and argument in the lower court about whether or not there are certain things in an indictment that must be dismissed because they fall under absolute immunity. And that's going to be a whole other thing, as we said, with, and this was even suggested as a possibility in the argument. So with briefing, a decision by the lower court, an appeal to the circuit court, and maybe the Supreme Court, the practical effect of that is any of those cases will not be complete by the election. So yay. So that's probably what you're going to have, which means this is just going to continue to drag out for months and months on end. Anyone who's hoping for a quick resolution, if they do that, if they pick the mushy middle, probably won't. The other interesting thing is, one thing everyone agrees and that the government conceded is to the extent the president has immunity, it applies to state prosecutions as well, which means if you have state prosecutions that implicate the official actions of the president, those will have to go through the same sort of argument, appeal, all that other stuff. The one case this would not affect, I think everyone would agree, is the one that is currently ongoing in New York, because that case is about stuff that happened before Trump was president. So presumably, no matter what the court said, that case would not be affected by this, but pretty much every other case would be, depending on what exactly the Supreme Court says.
Well, there you have it. Simple as pie.
And look, I mean, seriously, now that we've talked about this, go back and listen to the argument. It's 2.5 hours long, but I think now that you have sort of a basis, you'll be really interested by it. I think you'll find it to be pretty fascinating. And all the justices were very engaged. Justice Sotomayor asked a lot of great questions, particularly at the beginning when she's really trying to nail this down about what exactly the president could do and couldn't do. Justice Kagan, as I said, just really cuts to the chase. Justice Gorsuch is, really good at making you concede things. So listen to the arguments. I think you'll be fascinated by it. And like I said, hopefully now that you've got some basis in it, you'll be able to hear it intelligently and sort of draw your own conclusions about how the court should come out.
Yes, I think that's the bottom line, is go listen to it. Educate yourself a little bit more. But hopefully we were able to lay out the arguments for you so that you can follow it a little bit better. As always, we love to hear from you. You can email us at prosecutorspod@gmail.com. Reach out to us on social media, on X, Twitter, Facebook, Instagram, TikTok. I think I've covered all the things we have. We're at Prosecutors Pod. We really do love hearing from you. If you found this interesting and want us to cover more like this, let us know. If you hate it, let us know. We'll go back to hearsay and rules of evidence because we got plenty of those up our sleeve as well. But Brett, is there anything else you'd like to add before we sign off on this very easy case?
The only thing I'll say is the same thing I said when we got started. I hope people can put aside their feelings, either pro or con, for the subject of this litigation and dig into the legal and constitutional and historical questions, because they really are interesting. They really are complicated. And I think they go to something we've talked about before. I think I've talked about before, which is when you get to these extremes of power, whether it's the Supreme Court or the president or Congress or whatever, in the extremes of what their powers are, it really becomes hard. The Constitution, the rules of evidence, we talked about this before, all this stuff is great for 98%, right? I mean, the things that happen every day, they're great. The justice system is great for that. But when you have these, we talked about before, juveniles who murder someone, or the president attempting a coup, or what are the limits on the power of the Supreme Court when they're the Supreme Court? Like, when you get to these things, it gets tough. So I hope you guys can appreciate that outside of the obvious political implications.
Absolutely. Well said, Brett. Well, thank you guys for joining us for this particular recap of a Supreme Court argument. And look, we're going to find out from the court what they decide in a month or so. When that decision comes out, hopefully you'll have a better basis for understanding where those arguments came from in the first place. But until next time, I'm Alice.
And I'm Brett.
And this is the Prosecutor's Legal Briefs. Sorry.
You're right on the drink.
I know. Sorry about that. Oh, my goodness.
It was worth listening to, though. If you guys get a chance.
That was great.
It's,
I just scared everyone away in the parking lot while I was listening to it. But
I had a long drive, so I was able to listen to the whole thing.
I listened to some of it, but then my kids refused to listen to it in the car, so I lose that driving time, Like, this is boring. Let's listen to something else.
All
not
right.
boring.
When are we recording again, Alice?
You set the gold standard for your business. Your website should do the same. Wix puts you at the helm, so you can enjoy the creative freedom of designing your site just the way you want. Want someone to bounce your ideas off? Talk with AI to create a beautiful site together. Generate on-brand content, images, media, and simply change or fine-tune any of it along the way. Whatever your business, manage it from one place and tie it all together with a personalized domain name. Gear up for success with a brand that says you best. You can do it yourself on Wix.